Hello, everyone, and welcome to today's webinar live on August 31st. My name is Alyssa Atkins. I am the Training and Development Coordinator at the Native Learning Center. We are thrilled you could join us today. This webinar provides a summary of fundamental concepts, requirements, and/or procedures within the allotted 90 minutes. The material discussed does not illustrate all possible scenarios that could be applicable. Before we get started, I wanted to familiarize you with some of the features available and how the environment works. If you look at the top of your screen, you will see an icon of either a person with their hand raised or just a hand. With that icon, you can either raise hand, agree, disagree, or step away. Now your screen should look similar to this graphic here. To the bottom left, you will see a box that says Files. Here you will find today's presentation. Please feel free to download a copy for yourself. Simply click the item you would like to download, then click the arrow pointing downwards, and you will be prompted to save or print the materials based on your device's permissions. I highly suggest that everyone at this time take a moment to go ahead and download or save the Day 2 presentation PDF form. This way, I know it's a lot of information, so this way you guys will have the PDF to refer back to once Cheryl is done with her presentation. This way you have something to look back at since it is a lot of info. The second box that states web links to houses today's surveys as well as any other links that are found throughout the presentation, including tomorrow Day 3 registration link, and the recording for Day 1. So just in case you guys also have the recording to go back to. Lastly, to the right of the screen, we have a chat box available. This is how you will communicate to the instructor and NLC staff. If you have any questions during the presentation, please feel free to interact by using the chat box. Simply type your message and hit enter or click that up arrow icon button to submit. We encourage class participation, so please feel free to write in those questions or comments. Tech support issues should also be submitted here. It is with a great pleasure. Oh, actually, Crystal, did you want to?
Yes, hi. Thank you.
No problem.
Okay. So just really quick before we go ahead and introduce Cheryl, y'all, for those who aren't so familiar with my voice, I'm Crystal Cedino, the Training Development Manager for the Native Learning Center. As of lately, I haven't been really facilitating these because I have EWONAP, which is great. It allows me to develop other curriculum and make our programs that much more informative. But with that being said, I did notice quite a bit of feedback on yesterday's session regarding timeliness or more requesting more time. If you were one of those individuals, that is totally okay. I need that feedback in order to make these sessions, like I said, even better. But what I would love is if in today's feedback, you can specify what specifically you would love more time of, because these sessions are broken down so that we're not sitting here for 8 hours or 10 hours worth of content, because NAHASDA, as I'm sure we're all aware now, has quite a bit of pieces, puzzle pieces that are in there. So that's just one small request that I have as you fill out the feedback. Again, the more specific you can be, the easier, I should say, it is for us to try and accommodate that. But other than that, that was all I had. I hope so far you're enjoying the sessions. It seems like you all are, and I appreciate all of you. So with that, I'm going to end my little montage here, and I'm going to go ahead and pass it off to Cheryl. So thank you, Alyssa and Cheryl.
Hello, everyone. Good afternoon. I did send up some smoke and prayers on behalf of us all. This presentation is courtesy of the Native Learning Center, and we are being recorded. Here is my contact information should you ever need me for anything. If I'm teaching, I can't get back to you immediately, but if I'm not online or on travel, I always try to respond very quickly if somebody has any questions. My information can also be found at the end of the presentation. I went through this yesterday, and I don't know if any of you are new, but I come from Bay Mills. We are Ojibwe Chippewa people located our reservation at the top of Michigan in the Upper Peninsula, 5 miles from Canada by water. I served as my tribe's director of housing for 28 years and on the national level for 14 to 15 years, as well as chairperson of our local housing organization. These are the appendix items. Again, this is something else that I would recommend that you download for your future guidance. If nothing else, your program guidances and your PIH notices, you should have a copy of them somewhere so you can grab them when it comes to, especially if you have a board of commissioner or you have a tenant or somebody say, or a staff member. Tell me why. Why is this policy written this way? Well, because we're complying with the law. If nothing else, on one of your computers, on your server, put all your PIH notices, put all your program guidances, and most definitely Appendix 1, 2, and 3, because you need the statute and those regulations and Part 200. Now, those items are updated occasionally, so always try and check every couple of months to see if your version is updated there also. Your policy status table, I would highly, highly recommend that you start that depository and make sure that you have that policy status table so you can look at your documents and make sure that they're up to date, especially the required ones. But so you know where they all are within your office. When you're onboarding your board of commissioners, they should have a place where they can go and sit down and pull down a binder and, okay, this is the A&O policies for this program. You should have that depository of those really, really important items. Plus, it'll make you have them. They're the latest adopted version. And when somebody requests them, you're not coming out, or your staff isn't coming out with 5 or 6 different versions that say draft on them that have no proof of adoption. And that you can actually, as part of your self-monitoring, go through and make sure that they're up to date. Make sure that you don't have conflicting information within your own documents. So I would recommend that. Again, we went through, our objectives to hopefully identify all the required policies and our certifications of compliance that our organization should have in place. Now, today's presentation is a little bit different. It's going to touch on those. There's a whole bunch of different little policies that a housing entity almost needs in place to run cohesively. I mean, and I couldn't section them off. So you're going to see when we get into it, but hopefully it's going to help you along the way. And I'll try to explain why they're necessary. So I'm going to try to finish up by 3:20. I was a little late yesterday. Pushed you 5-10 minutes too late, and I apologize for that. So we can get to that all-important survey. Make sure, Crystal has a real hard job. She's in Florida, not at a housing authority, doesn't really always know. She knows how complicated our programs are. I guarantee you that. But she doesn't know the different factors of all of them and those components that we need to build in. So let her know, So A&O policy outline we went through yesterday, touched on that non-low income assistance. We're probably going to touch on your self-monitoring, your grievance, other federal laws, and things like that today. And this is day 2 of 3. We had someone yesterday that didn't know we had any additional courses. So we're going to be around one more day after today. So this section is our assorted policy language, okay? And as I said, it's going to bounce around a little bit. So has your policies within your A&O touched on an emancipated minor. Sometimes it's not there until you have somebody come in and say, well, I'm legally emancipated. And I was at 15. That happens. Sometimes those people that actually do that are more responsible than some of the 30-year-olds you house. But that is totally up to you. But you should have language, whether you're going to recognize them or whether you're not. And as I said, this is always suggested or possible language you can use for your policy. Always have your attorney, your lawyer, your legal staff, somebody look at all of it. Make sure you're not conflicting with any tribal law, as well as federal and state law, when you put together your policy. So a head of household must have reached the age of majority, 18 years, and that's our standard language, to sign an occupancy agreement, unless he or she has been declared an emancipated minor. An emancipated minor is often a teenager with a child, or a married couple where both the husband and wife are under the age of 18, verifiable by documentation confirming that court action. So it's a discussion you have with your board, with your leadership. Do we want to service emancipated minors? That would be the language. Your language in your policy could read a minor head of household. If the head of household applying for services is a minor, then a court order emancipating the minor as an adult is required. So your social security numbers. Your social security numbers are required for verification purposes. Your applicants must provide the housing authority with a complete and accurate social security number for each member of the persons listed on the application who's over the age of 6. The applicant must provide documentation of that social security number provided, such as a valid card or other evidence of a social security number. If they don't have this documentation, the applicant must submit a signed certification stating, this is my social security numbers, and you need to write this in your policy, how long you're going to let them or give them, what is the period of time until you expect them to bring that documentation in. 60 days to accept this documentation of the social security number. You could also put in language, the 60-day period can be extended another 60 days for an elderly applicant at the sole discretion of the housing authority. Our social security numbers are required to verify a vast range of information relative to the processing of our applications for housing assistance. The following is a list of some of the examples how one social security number can be used, but it's not all inclusive by any means. For identifying the validity of the person in an automated record, identifying the person in debt collection efforts, identifying the person while you're running that criminal record effort, cross-checking the identity of the person for participation in other housing programs, identifying the person in your social security records and for payment, or identifying the person for Internal Revenue Service records if you're pulling down your wages and your income that way. So that applicant, must furnish, and I always use that ATIHA, that's the Any Tribal Indian Housing Authority, housing department with the Social Security for himself or herself and each family member or person listed on the application. You could extend that over the age of 6, put that language in there if you wanted. Because of problems with fraud and abuse by applicants, perhaps using another person's SSN, applicants are required to provide the housing department with an original card issued by the Social Security Administration for themselves, their spouse, significant others, because remember, as a head of household, those are like the 3. They don't necessarily have to be married as that co-head. All children planning to reside with them, any other individual planning to reside within that household and that applicant family. The Social Security cards are required because they link that individual's name with his or her Social Security number. The ATIH Housing Department staff shall make a copy for its records and return the original to the applicant. Now, that is another area that you have to have that discussion with your leadership. We talked about a depository for your personnel policies, your procedures, your housing policies as a whole. Well, you might be the tribal depository also. We had that discussion with our leadership, and oftentimes, and I said I had no problem with that. My staff shouldn't. We're there to help our people, our members. They're going to give you copies of Social Security numbers, cards. They're going to give you copies of birth certificates. And when they can't find them in their house, guess where they're going to go? They're going to go to the housing authority. Just make sure that you have a form or something that you're making sure that the proper parent within that household, you're giving them, you can't be giving that to somebody that doesn't live with them, even if it's the dad or whatever. You should have some rules and regulations as far as that go, but you can provide those copies to them, because oftentimes they'll misplace or they'll lose them, and it's more often easier to get a replacement if you have a copy. So are you going to be the repository or not? That's another little thought that you guys have to think about. No Social Security number. Adults, those adult family members who do not have a Social Security number assigned to them shall certify to that fact and then immediately apply for a Social Security number. Minors, the head of household or spouse or significant others must execute a certification that a family member under 18 either does not have a Social Security number or a card, or that they are going to apply for one immediately. Okay. A continued need for verification of that Social Security number. Once you have, or that particular family member has documented your Social Security number, you don't need to re-verify or redocument that Social Security number. Unless the family adds a new member to the household composition, the new member at that point should be disclosing that document or certifying that none has been assigned or initiating the process to obtain one. If a family member is assigned a new Social Security number, that the family member must disclose and document the new Social Security number to your housing department staff. If a family member who previously certified that they had no Social Security number has now subsequently got one, then that new Social Security number must also be disclosed and documented with your housing department. The tenant responsibility for families and guests. This is hugely important because of the fact that you can evict somebody because of their guest behavior. You need to make sure that they know that. They need to understand that in writing, in your policy. They need to understand that when you're going through that initial occupancy. Now, a little bit about your initial occupancy. When you're going to have that conversation with the tenant, they're going to be a brand new tenant and they're going to move into a house. You have a very good idea when somebody accepts a household from you. Now, if their verification information has been done within the last 30 days, that's good. If it hasn't, you need to run it again, just in case there was that change of income. And then you need to get them in there as soon as possible to sit them down and run through what you expect of them as a tenant, what you're going to provide, what they should provide. At this point, the tenant responsibility for family and guest discussion needs to take place, as well as your maintenance staff, for instance. You need to, implore upon them, please don't wait until Friday at 4:00 on a holiday weekend to say you have a running toilet if it's been running like that for a week. They need to realize how important your staff time is also, and when they should be. What is an emergency? What isn't an emergency? Run through your maintenance things with them, because that's not fair to your staff either. Certain things like that, your expectations of them and what they can expect out of you. What I would suggest, though, is you don't give them the key, and you never let them store anything in a unit before you're doing that walkthrough and they've accepted that unit. Okay, you're asking for trouble there. But go through that procedure as early as you can, because if you wait until the day before you're going to hand them the keys, you guys can move in to do this with them. They're going to be sitting in the chair and you're going to be telling them all their obligations. And they're going to be saying, I need to buy a shower curtain for the upstairs bathroom. I've got to get a new wastebasket for the kitchen. You know, I got to get that washer and dryer scheduled to come in. All of that's going to be running through their head rather than what you need to tell them about their obligations. So try to get that done as soon as you can also. But your tenant responsibility for that families and guests, they need to understand that. Grandmas and grandpas need to understand that about their grandchildren also. The tenant, head or spouse, is responsible for all the actions of the residents, guest, family, children in the home and shall be accountable for their actions. You might have to kick them out if their grandson is in there pushing drugs, okay? Unauthorized use of that unit. Tenant shall not use the unit for any purpose other than as a primary resident. No business may be conducted from the unit or premises without your written approval. Tenants may not sublease, assign, or let the premises to any boarder or lodger at any time, nor permit any unauthorized person to reside in the unit who has not been added to the household composition form and approved for occupancy by your housing entity. You also need to include some language. If you evict somebody from your housing projects or your housing units, are you going to allow them to stay in another one of your units? If not, you need a list of people that are prohibited from your premises. And your tenants need to be aware of that they're jeopardizing their own housing by bringing this person in. Also, you're going to have those conversations, and they're often difficult. Somebody's coming back out of jail for this. Are you going to allow them in your units? Are they going to be able to go live with grandma or dad or whatever? What if they're a sex offender? Make sure your policies and your procedures, speak to all of that. Your utility allowances. Remember, our utility allowances are no longer required. You should perhaps, if you offer them, include language that no utility reimbursement will be provided should that utility allowance exceed the total tenant payment amount. You don't want to go backwards. They have a $90 payment and a $150 utility allowance. You don't want to be owing your tenants money. What about your disability, your accessible units? A housing unit that has been modified to accommodate the physical needs of a person with the disabilities. That's your definition for that. You need to have policies about who can go in those units. What if it's the only unit you have left and then you have a disabled household come in and apply? Do you have a provision for that? Your tenant account balances, your TARs. The ATIHA shall maintain for each tenant or household an account ledger, always showing the current account balances of charges. The account balance includes any rent charges or homebuyer charges, the credits for utility allowances if applicable, charges for maintenance of the unit, premises, resulting from tenant abuse, neglect, failure to perform their responsibilities under the lease, including maintenance of the yard and the lawn. Have something in your policy that if they don't mow their lawn and you give a warning and it's still not mowed, you can have somebody else mow it and charge them. Same thing goes for snow removal on a roof. Make sure you have those provisions in there. Your TARs are an important thing. You usually won't you don't get findings for TARs anymore, your tenant account receivables. But everybody looks at them to see how well you're running your business. You shouldn't have huge TARs. If it does, it tells you that you don't have a good collection policy in place or somebody's not following it. An employee handbook. Are you guys an at-will employer? Does a new applicant know what an at-will employer is? The employee handbook describes important information about the ITHI. I understand that I should consult with the HR department if I have any questions that aren't answered in the handbook. I became an employee at ATIHA voluntarily. I understand and acknowledge that there is no specific length to my employment at ATIHA and that my employment is at will. I understand and acknowledge that at will means that I may terminate my employment at any time with or without cause or advance notice. I also understand and acknowledge that at will means that ATIHA may terminate my employment at any time with or without cause or advance notice, as long as it does not violate any applicable federal, state, or tribal law in doing so. I understand and acknowledge that there may be changes to the information, policies, and benefits in the handbook. The only exception is that ATIHA will not change or cancel its employment at will policy. I understand that ATIHA may add new policies to the handbook, as well as replace, change, or cancel existing policies. I understand that handbook changes can only be authorized by the executive director of ATIHA. I understand and acknowledge that this handbook is not a contract of employment or a legal document. I have received the handbook and I understand that it is my responsibility to read and follow policies contained in the handbook and any changes pertaining to it. Your cell phone use policy. Now I kind of learned this one the hard way as an ED because we have a lot of snow here. It snows from Halloween until May at some point. And my guys plowed a lot. And there I'd have cell phones land in coffee cups while they were plowing, hit the snowbank, things like that. You also don't want to be liable because you have a staff member talking on a cell phone while they're driving. So make sure you have a cell phone use policy. If you're providing too much internet, they shouldn't be home streaming, movies or anything like that. You might have it on use and consumption, what it's to be used for. This is a very simple, no handheld cell phone use while driving. An employee who uses a company-supplied device or company-supplied vehicle is prohibited from using a smartphone, cell phone, hands-on or hands-off phone or similar device while driving, whether the business is conducted is personal or company-related. This prohibition includes receiving or placing calls, text messaging, surfing the internet, receiving or responding to email, checking for phone messages, or any other purpose related to your employment. Housing business, our tenants, our vendors, housing activities, or meetings while driving. Use of a company-owned vehicle or device for personal business is discouraged, but you need some type of, if you're supplying a cell phone, you need a policy. But sometimes you need that policy for use of their own personal cell phones while they're driving your vehicles also, okay? Just something to think about if you don't have them. Your essential families. We touched on this yesterday. Some of the requirements. Essential families must meet other ITIHA policy requirements, and housing must be available. You're not going to house an essential family and boot somebody else out because you deemed them essential. Essential families include, but are not limited to, and you make up these definitions. Medical personnel. We definitely had a hard time getting dentists and doctors into this area. So they oftentimes would come and the community would deem them essential because they needed those services for our people. School personnel, whether it be for our college or community college or our charter school. So depending on where you're at, if my guys that are in Oklahoma here, you're in the middle of a city. You guys have a lot of rental opportunities outside of the area. But where we're at, we're 25 miles to the next town, and there's hardly any housing there. So we do use the families requirement up here. public safety officers, your law enforcement, Coast Guard and other personnel, firemen, employees of the tribe, spiritual leaders, religious officials, others as determined by the executive director or the board of commissioners. Now, you have to make sure when you create that essential families policy, who may deem them essential. Make sure that you have that component within there. A dependent, a member of the family household, excluding foster children. Now, that is a carryover that hasn't been fixed yet from public housing. Okay, we're not supposed to give a dependent deduction to a foster child. Now, in Indian country, we take care of our family. That's the easiest way to put it. I raised a grandchild. I had her more often than her mother did. She's 14 now, and this is probably the first year that I didn't have her over 3/4 of the time. That's just what we do. You can pass language if you want to give a foster care or a dependent deduction to one of your, your tribal members, to your extended family, to a foster child. It just has to legally be adopted by your governing body. A member of the family household, excluding foster children, other than the head of family or spouse who is under the age of 18, or is a disabled or handicapped person, or who is a full-time student. That's your definition of dependent. So our first poll of the day, do you guys have a child care expense policy? This is a legal deduction. Okay, 44, 10, 16. About half of you have answered. Okay, we're tied across the board, 9, 9, and 9. Anybody else getting an answer? If not, we'll go on. That's interesting. So that is a deduction that is a standard exemption across the board. So you guys should have that in place. And I don't know how to move this. Oh, there we go. So child care expenses enables a family member to be gainfully employed or further his or her education. So that is how your policy should read. The amount deducted should not exceed their employment income. So if Sally makes $200 making pies, that's the most she should be able to deduct for that child expense, okay? That amount is not paid or reimbursed. That's less money on their adjusted income. Child care expenses incurred to permit a family member to work must not exceed the amount earned by the family member made available to work during the hours for which child care is paid. So if Sally is making pies from 8 to 12 in the morning, she shouldn't be deducting child care at 7 o'clock at night. Okay, so that's the other point that you want to make sure that you have addressed in your policy. They are the amounts anticipated to be paid And then your child policy, your child care expense policy should also address the age. Some people I've seen advance that age past 13 if it's to take care of a disabled child within the home. It's up to you how you craft that policy. Amounts anticipated to be paid by the family for the care of children under the age of 13 years of age during the period for which annual income is computed, but only where such care is necessary to enable a family member to be gainfully employed or to further his or her education, and only to the extent such amounts are not reimbursed. The amount deducted shall not exceed the amount of income received from such employment. So there's some suggested language there. This is a child care verification form. There's all sorts of them available through different places on the net. All you got to do is look for them, but I would also suggest you have something like that in that packet. So when we talked about that foster child, that dependent deduction, this is possible language. Your ATIHA tribe has determined that foster children are considered family members and dependents. If they currently reside, and it can be reasonably anticipated that they will continue to reside within the family at least 6 months a year, or you could put 9 months a year, or whatever. You would also let them know, should that child move out, to please come and let us know, and we'll make an adjustment. But something, a type of conversation, because you're not supposed to be giving a dependent deduction for a foster child. Now, it also kind of depends on how your family looks at caring for that grandchild or that auntie or that, not auntie, excuse me, nephew or niece, because you're the auntie, it depends on that definition also. So it's just something to kind of look at that is missed quite a bit. And a lot of people don't know we're not allowed to give that deduction. So a care attendant is a person who resides with an elder, disabled, or handicapped person who is determined by the authority to be an essential to the care and well-being of that person. And they're not supposed to be listed on the family composition. Okay, so this should not be someone who will take over the unit upon an unfortunate death or whatever of the person they're caring for. Okay, so it's really not the daughter or the son being the care attendant. This is somebody from outside of the family normally, not listed on the family composition, and whose income would not be counted when calculating rent. Okay, that's why, because you do not count any income derived by a care attendant. So have your careful wording in there, whether it be in your policy or your procedures for your A&O staff, so they realize how that they should be calculating that, because there's confusion in that part. So our next poll question: do you have an excessive travel expense policy in place? This is another area that this is a statutory deduction. Okay, 10, 18, 19, 20, a couple more. We have a yes, we have more no's, and I don't knows. Okay, so that's another area you need to look at the statute, the regulations. You're supposed to be having this deduction for your peeps. Okay, you can close her up. You guys need to make sure that you go back and you look at the regs. That is supposed to be an area where you offer that particular deduction. The allowances for the benefit of families who must travel long distances, and you're going to make that determination. So, like I said, our nearest town is 25 miles from here. So our tribal council determined anything over 20 miles. We also have a college 25 miles from here. So this allowances for the benefit of families who must travel long distances, and you're going to make that determination of how long a long distance is to and from work or school. It's important to remember that this allowance can only be allowed for excessive travel for employment or education purposes. It must be reasonable. It cannot exceed $25 a week for the entire household, not per traveler. $1,300 per year maximum. So make sure you have that criteria and policy. You can request a map be attached should they ask for that. So you should also have, because I was in a place recently where there were people that didn't want to provide information. It should be within your guidelines, your policies, your procedures that they need to require, you need to require certain documents, and you should have a penalty or the what ifs if they don't. So failure to comply with annual interim recertification requirements. If a tenant fails to provide the information requested by the due date, it shall be deemed a failure to comply with the requirements of the lease, and as such constitutes a breach and may result in the termination of the lease. If the tenant does not file a complete annual recertification packet by the anniversary date of their move-in, or if you do them all at one time, you can say within 15 days of the request from the housing entity, tweak this to fit your needs. The ATIHA will proceed to issue a lease violation. If the tenant does not file a complete annual recertification packet within 7, remember when you're writing this, always specify business or calendar days, of the mailing of the lease violation, the ATIHA will proceed to lease termination. This is to make sure that you get the information necessary to run your program correctly. You can get a HUD finding by not having this information. One of the main reasons is to prove you're not charging them over 30% of their adjusted income, okay? So make sure you have something like that drafted up in there. I told you, we were going to be all over the place with some of these policies, but they're all important policies for one reason or another. So finance, your finance policies. Do you have a credit card use policy? Credit cards shall be made available to designated ATIHA employees or board members who agree to be financially responsible for properly using the credit card. The executive director shall designate the employees and designated board members who could possess and use the credit card. For purposes of this policy, any employee or board member possessing the credit card shall be referred to as a card holder. ITIHA credit cards are for authorized business expenditures and not intended to be used by employees or board members as a substitute for a personal credit card. ITIHA shall develop a written agreement that clarifies the employee's rights and responsibilities with respect to the credit card program. By the way, this can also apply to your tribal council members if they travel on your behalf. Employees who are assigned credit cards shall sign this written agreement to document their awareness of the policy, along with agreeing to the terms of the agreement. At a minimum, the agreement shall contain the following provisions. Authorized business uses. The cardholder agrees to use the credit card for authorized business expenditures only. Business expenditures must be authorized by the ED before charges are incurred on the credit card, in accordance with the policies, procedures, and practices. Valid business expenses may be authorized in writing retroactively. However, if this does not occur, the cardholder will be responsible for reimbursing and will reimburse ITIHA for such charges as if they were for personal use and erroneously charged. And I said that wrong. No personal use. The cardholder agrees not to make personal charges on the credit card. If the cardholder erroneously charges a personal item on the credit card, he or she agrees to reimburse the ATIHA within 30 days for the credit card charges for such personal use, including any finance, late, or penalty charges. Disciplinary actions may result from personnel use of a credit card. I had to terminate an employee for that. They charged stuff that they were going to cook at a powwow stand, basically to one of our vendors that we got supplies from. And you can't do things like that. Lost or stolen ATIHA credit cards. If the cardholder discovers that his or her credit card has been lost or stolen, he or she agrees to notify the credit card company immediately and the ATIHA on the first business day after discovery of the loss. Don't hide it and try to find it, If the cardholder fails to report the loss promptly, he or she will be solely liable to the ATIHA for any charges on that card. Credit limit. The cardholder agrees not to exceed the credit limit established. If a higher limit is required, the cardholder agrees to submit to ATIHA a request for the new credit limit along with justification. Payment of credit card billing. ATIHA will ensure all billings charged on the cardholder's credit card are mailed to ATIHA. ATIHA will pay all amounts charged to the cardholder's ATIHA credit card. The cardholder will reimburse ATIHA for all amounts erroneously charged or not authorized. Disciplinary action may result from unauthorized use of a credit card. Receipts. The cardholder agrees to submit to ATIHA within 1 week of a transaction the receipts for all expenses charged on his or her credit card. Examination of billings. Upon the request of ATIHA, the cardholder agrees to examine billings for his or her credit card to assure that all the charges are valid. If there are incorrect charges, the cardholder agrees to notify ATIHA immediately and as requested to complete and return any forms for disputing charges to the credit card company. If the cardholder fails to report incorrect or disputed charges promptly as required under this paragraph, the cardholder agrees he or she will be liable to ATIHA for any resulting charges. Changes in name. The cardholder agrees to notify ATIHA of any change in his or her name as it appears on his or her credit card. Surrender of the card. The cardholder agrees to surrender his or her credit card upon demand by ATIHA or when there is no longer a business need for the card, or when his or her employment with ATIHA is terminated. The cardholder agrees to pay all monies owed to ATIHA upon his or her surrender of the credit card. You could also put language and it will be deducted from their last paycheck. Disciplinary action, cause for removal. The cardholder must acknowledge that misuse and or mismanagement of the credit card may result in a disciplinary action against the employee, including but not limited to termination of their employment, including but not limited to disciplinary action shall not relieve an individual from the responsibility to repay the amounts wrongfully charged. Referral for criminal prosecution shall be required unless circumstances warrant forbearance in an individual case. Termination. If the ATIHA terminates a credit card, the cardholder shall, upon receipt of written notice of termination, surrender to the ATIHA the credit card and possible criminal prosecution. Log. Each credit card shall be maintained in a locked cabinet or safe until needed. A log shall be kept at the location where the user shall sign the withdrawal of the card for an authorized purpose. The executive director shall periodically review each log to guarantee that the log is being used and that each card is returned immediately upon completion of each use. So, those are some of the things you should have in place to cover your 6 in case of a credit card. Self-monitoring. Why? The importance of self-monitoring. You need a policy for this. You're certifying that you have a policy, you have procedures, and you do this when you complete your APR on a yearly basis. So that means at least once a year, guys, you're supposed to be doing self-monitoring. You can do that all year long. Every time that somebody messes up or you discover things that could be done better, you can build that in as part of your self-monitoring. Hey, this is what we found and this is how we're going to fix it. So that self-monitoring, it ensures that compliance with your rules and your requirements, compliance with the tribe and the TDHE policies and your procedures, your consistency with your Indian housing plan, okay, because remember it's supposed to be done with your annual performance report, your efficiency, your effectiveness. It demonstrates accountability for your performance. It builds your organizational capacity. It ensures compliance with the regulations. It'll help identify some of those system weaknesses and hopefully improve efficiency and effectiveness of the practices that you have in place for your housing entity. It's the process of recording the operations of your systems, observing and reviewing activities over the course of a whole year, detecting deficiencies and taking steps to hopefully correct them, recording and reporting through your annual compliance assessment and annual performance report. Observe and review activities over the course of a year, detect deficiencies and take steps to correct them, report through an annual compliance assessment and your annual performance report. And for assessing compliance with your IHP, this is what I said I was going to do. This is what I did. The law and those regulations that we have to follow. So, how many of you have ever taken place or taken part in the self-monitoring for your organization? Okay, 16 of you have taken part in it. That's awesome. 7 says no. Yeah, I was going to say, and you shouldn't have any I don't knows because you should know if you're doing it or not. Okay, so you can get rid of, bring that one down, my girl. Okay. So the requirements under the statute, NAHASDA 403B, periodic monitoring. Not less than annually, each recipient shall review the activities conducted and housing assisted under this Act to assess compliance with the requirements of the Act. Such review shall include an on-site inspection of your housing. Okay, so you're supposed to be checking that housing on a yearly basis. Now track that. When you go into a unit, you do a move in, you do a move out, that can count as your yearly inspection because you've done a thorough inspection of that unit. So that's one less unit that you have to actually inspect that year on that chart. So make sure somebody's charting that for you. It'll lessen your load at the end of the year to hit that compliance requirement. The results of each review shall be included in the performance report of the recipient submitted to the Secretary under Section 404 and made available to the public. So that's the requirements under the statute. Now, of course, the regs have something to say about that also under 502. The recipient is responsible for monitoring your grant activities to ensure compliance with the applicable federal requirements and monitoring performance goals that you set forth under your Indian Housing Plan. Recipients must monitor grant activities in accordance with your Indian Housing Plan, complete a compliance assessment, including your unit inspections, develop a corrective action plan to address any areas of noncompliance, must include a summary of results and corrective actions in your APR. So that's, you got to make sure that you're reporting on that within that APR. You monitor your performance against your goals. You check the relevance and quality of your activities. Identify issues internally, hopefully before any other partners, and solve your problems promptly. So you can put together a self-monitoring schedule to give yourself time to have that completed by the time the APR is due. One of the things that I always you guys need 5-year calendars. You can get them through Amazon relatively cheaply, but a 1-year calendar does not cut it in our line of business. We have to project out and go backwards too often. Also, I used to have one, you jot down when somebody within a household is going to be 18. Why? Because then you need that release of information signed by them. When is their recertification due? When are the inspections due? Your self-monitoring, you have to back up. We got to get on the tribal council schedule or the housing board schedule. What happens if they cancel that meeting? So you should probably back up 2 months before you provide some of this information. You have that public comment period. Should at least be 2 weeks, so you got to back up 2 more weeks before that thing is due. So you have to use those calendars to back up and make your schedules. And your self-monitoring should be part of it because there's always individual components. So on your IHP, you're certifying. Do you have a procedure and policy for self-monitoring? Your ED, or, you're answering yes or no. Pursuant to 24 CFR 1005, maybe 20B, I can't read it, it's too small. Where the recipient is a TDHE. Does the TDHE provide periodic progress reports, including the self-monitoring report, annual performance report, and audit to the tribe? Because your board of commissioners aren't the only ones that's supposed to be getting this. The tribe is overall, totally responsible for your being and what happens. So they're supposed to be getting that information. Do you conduct self-monitoring, including monitoring of your subrecipients if you have any? Because you're responsible for that if you have anybody in that kind of position. Your self-monitoring results. Describe the results of your self-monitoring activities, including corrective actions planned or taken. So that's why you have to, that's all supposed to be done and completed prior to your board approval, prior to your comment period, prior to when that APR is due. So you got to backtrack in the calendar to make sure you hit those deadlines. So this page has actual links to monitoring plans, okay? If nothing else, use this. This thing is absolutely great. You can pass them out to the different departments. If you use the ones for occupancy in your tenant file reviews, you're going to catch half of your own mistakes. And if you look in there and it says, I have no proof, because this was before I got here, that this family was eligible at the time of admission, well, make that part of your self-monitoring. Put a great big old sticker on the front, no proof at the time of admission that family was, and you caught your own mistake, okay? It's a bad thing, but hey, you caught it as part of your self-monitoring. So use these forms. They're really, really good. And I would definitely suggest your different departments try to review these, and that'll help with your self-monitoring. So you should have a self-monitoring policy, policy statement, conducting compliance assessments, approaches, methods, monitor your strategy, your plan, areas to be monitored for compliance. You might not hit them all within a year, but make sure you're looking at something and don't keep hitting the same ones year after year. Resolutions of noncompliance, areas and issues, and reporting. This is sample policy. The governing body basically recognizes the fact that they're responsible for establishing a self-monitoring policy. Conducting compliance assessments is required by Section 403 of NAHASDA and 24 CFR Part 1000, Subpart F, entitled Recipient Monitoring, Oversight, and Accountability. The policy is to be utilized by the housing entity to ensure compliance with applicable federal requirements and monitoring performance goals described within their IHP. As a NAHASDA grant beneficiary, the housing entity is responsible for monitoring programmatic compliance requirements of the IHP and NAHASDA. Therefore, the housing authority is going to prepare periodic progress reports to submit to the Housing Board of Commissioners, along with an annual assessment, the APR, and a copy of the fiscal audit that's conducted. The policy is intended to establish an easy-to-use compliance assessment system that includes self-monitoring procedures to be used by the housing authority as a management tool and operating as a property management business. Conducting your compliance assessments, your assessors, who are they going to be? The executive director shall determine each year what approach should be taken in conducting the self-monitoring compliance assessments in accordance with this policy. The ED shall assure that the assessments are conducted with an objective and an impartial perspective, and that no one is reviewing his or her own work, okay? Because if they find a mistake, they're going to try to correct it and they don't want to look bad, So the approaches that may be used to conduct the compliance assessment include, but are not limited to, the following. Develop a housing assessment committee comprised of staff, members of the governing body and/or council. Procure the services of an outside third party who has the technical knowledge and experience in the areas being assessed. Now, before I go any further here, I had somebody as a result of this class ask, do they have right during self-monitoring to look at tenant files? It depends on their position. Now, if they're a paid consultant, procured, yes, because you have all of those within the contract things that would protect you. If they're your tribal council, your board of commissioners, yes, because they're employees, they're board members, they've got confidentiality statements, they've got, scope of, all of that is put into place. Now, if you're using just a tribal member, you need to put in other protection mechanisms because that's personally protected information. And what are you going to do if they go blab? So your self-monitoring assessment, you should probably have your legal staff look at that. Make sure that there are the proper forms in there. Make sure it's advertised correctly. If they are not board members, tribal council members, employees of, your housing entity, or even they would probably be covered as staff members of the tribe, okay? I would still get some policy or some, confidentiality statement signed and things like that. But somebody that you have no jurisdiction over, I would think twice about it. I would definitely have the legal department take a look at it, okay? Just protect yourself because that's confidential information in those files. Methods. The executive director shall work with the compliance assessors to determine the most effective method, combination of methods to utilize while conducting the self-monitoring compliance assessments in accordance with this policy. Conducting the compliance assessments may be achieved via the following methods. Interviews with managers, program administrators, sorry guys. The assessor shall complete self-monitoring checklist by conducting one-on-one interviews with respective managers or administrative personnel to obtain their insights into how they adhere to specific compliance questions. The assessor, shall gather a sufficient amount of corroborating information to exercise his or her judgment in determining the consistency and degree of adherence to the applicable regulatory requirements. Your standard operating procedures review. The assessor shall review the Housing Authority's standard operating procedures, including all of the policies, governing documents required by NAHASDA, as well as contracts, established internal controls, and the assessor shall analyze how well the staff adheres to the adopted policies and procedures. The assessor shall also select a random sample of transaction files and determine whether the documentation included and recorded in all the files conform to established operating procedures. The assessor shall also compile and analyze the information and answer the compliance questions on the checklist. Facilitated sessions. An independent third party shall act as a facilitator and conduct self-assessment workshops with the managers and administrative staff to talk through the monitoring checklist questions as a group. The role of the facilitator shall be to lead the group's discussion and bring the group to consensus on the appropriate response to compliance questions. Filing. The assessor shall file pertinent information and lessons learned throughout the self-monitoring compliance assessments. The previous year's self-monitoring file shall be made available to the subsequent year's assessors. Your monitoring compliance, your strategy, and your plan. Your ED shall develop and complete a monitoring strategy and plan each plan year encompassing the following items: self-monitoring compliance assessment start and completion, approach to take and conduct and complete the different compliance assessments as described in 2.1a, frequency of conducting and completing the compliance assessments, so you can do it annually, semi-annually, or quarterly, procedures to resolve any identified deficiency or concerns. The ED shall provide a copy of the monitoring strategy and plan to all staff, the housing board, tribal council, and any amended plan shall be distributed to the same individuals. Your policy, areas to be monitored for compliance. The different areas, and you would list your areas: APR development, IHP monitoring, organization and control environments, resident eligibility and service standards, fiscal and financial management, procurement and contract administration, labor standards and construction management, your environmental reviews. Additions to the list, the executive director may add any additional areas to the list as recommended by your governing body or by any HUD development notices, guidances, and guidebooks. Resolution of your non-compliance areas and issues. Recommendations. If deficiencies are discovered during the assessment performed in accordance with these procedures, the executive director shall establish a recommendations for improvement plan to ensure resolution and prevent the deficiencies from reoccurring. At a minimum, this plan should identify compliance deficiencies, the improvement target, action steps to reach the target, budget implications, and target dates for resolution. The recommendations for improvement plan shall be submitted to the governing body within 30 days of the completion of the assessments. Oversight responsibility. The executive director shall be responsible for providing oversight to ensure that all deficiencies are corrected and for concurring on the closure of each identified agency. Reporting. The Housing Authority's self-monitoring compliance assessment activities conducted in accordance with this policy shall be summarized in a report and presented to the governing body. The self-monitoring compliance checklist is not required to be submitted with the APR. However, to demonstrate that the ATIHA is in compliance with 24 CFR Part 1502, the Housing Authority shall submit a summary of its self-monitoring activities along with the APR. The Housing Authority shall also complete the required responses on the APR form related to self-monitoring. Okay, release forms. Your applicants are required to sign and date a form that authorizes the Housing Authority staff to request information concerning eligibility for tribal and/or federal housing assistance. If the applicant refuses to sign the release form, it would preclude the Housing Authority from being able to process an application and thus render it incomplete. The head of the household and all other families whose income, assets, other circumstances require verification must sign a form verifying employment, providing permission for the Housing Authority to ask questions about and verify information related to the family's income and other circumstances that affect eligibility and the amount that the family must pay. Applicants must sign the form as a condition of admission and continued occupancy. The Housing Authority must ask applicants to execute the form, even in cases where the person has not reported any income. Applicants may also be required to sign additional release forms if needed to authorize the staff to request other information regarding the applicant's income, assets, expenses, deductions. And you should also have a HUD fraud rider on your packets, okay? To all applicants, the program fraud remedies and the regulations, up to $5,000 for filing such a claim, plus up to twice the amount of benefits that were fraudulently received. You should have some type of a fraud rider on your packet so they know. You can put one up above the thing with your applications for all your programs. Something saying do not, you need to take very, very seriously answering these forms correctly, just so they're aware. So you need an applicant tenant grievance policy also. The purpose is to assist in resolution of complaints by your program applicants and tenants to afford program applicants and tenants a fair and reasonable opportunity to have their responses heard and considered by the housing entity. It's not intended to provide a forum for an aggrieved party to challenge your policies, your tribal, federal, or state codes, requirements, and/or regulations to settle the domestic disputes or to resolve matters which are more appropriately a police or a court matter. The scope, it should apply to all program applicants and rental and homebuyer tenants, also referred to as your participant. Grievances regarding actions for which a court hearing is necessary to carry out your housing entity action, such as an eviction or a termination in tenancy, are not subject to your grievance policy. Because of the any tribal court will afford your claimants an opportunity to be heard on the merits of their particular case. The grievance process does not apply to your employees, except as they could file a grievance if they were one of your participants. Nor does it apply to vendors or contractors, but you need to have that grievance policy in place. Definitions. A complainant is any tenant who has presented a grievance to the housing entity in accordance with the grievance procedures. A grievance hearing is the process by which the Board of Commissioners or your tribal council or whoever your governing body is hears an appeal by a complainant dissatisfied with your executive director's decision. A grievance is any dispute by which a tenant may have with respect to action which adversely affects the individual's tenant rights, duties, welfare, or status. An informal hearing is the process by which complaints are first considered by the appropriate housing staff. A tenant is a lessee or the remaining head of household of any tenant family residing in housing accommodations owned or leased by your housing entity. Your due process. Your grievance policy shall comply with the Indian Civil Rights Act if applicable, and shall assure that applicants and residents in all programs and developments will be advised of the specific grounds of any proposed adverse actions by your housing entity, have an opportunity for an informal hearing, and afterwards, if warranted, a hearing before your governing body upon a timely request as outlined within your policies and procedures, have an opportunity to examine any documents or records or regulations related to your proposed action, be entitled to be represented by another person of their choice at any hearing, be entitled to ask questions of witnesses and have others make statements on their behalf, and be entitled to receive a written decision by your housing entity on the proposed action. You should have that method outlined, how they go about filing that complaint. Complaints pertaining to neighbors who are ATIHA residents must be made in writing using a complaint form. Okay, this is very, very important. You guys need to develop a complaint form, and anytime you make a complaint or you receive a complaint, make sure that it's in writing. If they won't take the step to put that thing in writing, then you shouldn't be dealing with it. Now, should it be somebody who has trouble, they could be a functional illiterate, whatever the reason, you can have a staff member help them write that complaint form out, but make sure that it is in writing, okay? So your residents, complaints pertaining to neighbors who are also residents must be in writing utilizing your complaint form. Assistance in writing the complaint will be made available to the resident at resident's request. All complaints pertaining to any action of your housing entity are to be presented first on an informal basis, either orally in writing to the appropriate staff within 10 working days from the date of the action. If the complaint remains unresolved, the complainant must request an informal hearing with your executive director. You need to have a chain of command. It does not automatically go up to the tribal council. You're asking for trouble. You need to run your programs from within. There should be that chain of command. Before filing, and you need to make sure that your Board of Commissioners and your tribal council know that. This is the procedure that we have in place. Before filing a complaint with the executive director, the complainant should review the program agreement he or she has with your housing entity to assure that they have a valid complaint. Regardless of the nature of the complaint, all payments due to your housing entity are to be paid as agreed upon per your lease agreement or any promissory note or other repayment plan in the amount equal to the amount paid in the month preceding the complaint, plus any fees if you add any. An informal hearing. Complainants dissatisfied with the appropriate staff's decision can request an informal hearing with your ED within 10 working days of the appropriate staff's decision. The request for an informal hearing with the ED may be submitted orally or in writing, but must contain at least the following information: the date of the action disputed, the action taken that is being disputed, reason for the dispute, or other justification and relief sought. The ED will then schedule a meeting with the complainant as soon as possible, time and place reasonably convenient to the complainant, and will notify the complainant in writing. If the complainant fails to show up for the scheduled meeting without notification, the right to the hearing through your grievance policy will be waived, and the complainant shall be so notified in writing. However, this does not constitute a waiver of the complainant's right to contest that decision through legal proceedings in tribal court if they want to go that way. The ED will attempt to consider all the facts associated with the complaint in order to discuss and hopefully resolve the complaint without the necessity of a formal hearing. The executive director and complainant shall make every effort to attempt to resolve a grievance prior to the complainant requesting a grievance hearing. A written summary of the discussion and the executive director's decision will be sent to the complainant within 10 working days of the date of the informal hearing. The summary will include names of the participants, date of the meeting, nature of the complaint, the ED's decision and the basis of the decision, and the procedures by which a formal hearing can be obtained. The request for a grievance hearing, if the complainant is not satisfied with ED's decision or does not receive a decision from the ED, he or she may submit a written request to the executive director requesting a grievance hearing before the Board of Commissioners or the Tribal Council. The request shall be submitted within 10 working days from the date the ED's written decision, or if a decision was not rendered, 10 working days from the date of the decision was required to be rendered. The complainant's written request shall be considered a notice of appeal, and it must specify the following information: the action taken that is being disputed, the reason or justification for the grieving, the action, and any other information you would like the ATIHA to take into consideration regarding the action. The action or relief sought. If the, sorry. That's my hurry up and talk, Cheryl. Is what that one was. If the complainant's request for a formal hearing is not in accordance with item 105B, the executive director or designee will attempt to assist the complainant with the proper procedures. If the complainant does not request a hearing within 10 working days as required above, the complainant waives his or her right to a hearing, and the housing entity's proposed disposition of the grievance shall become final. The ED shall send written confirmation of the date, time, and place of the Board of Commissioners or Tribal Council meeting in which the grievance will be heard, and the ED will notify the board of the request and provide copies of the materials relevant to the appeal. Procedures governing your grievance hearing. The grievance hearing shall be held before the Board of Commissioners or Tribal Council, who will act as the hearing panel. The chairman of the Board of Commissioners or Tribal Council chair will preside over the hearing and ensure that the rules or procedures are followed. Review by the board will consist of a review of all the facts presented, procedures of your housing entity to ensure the protection of the tenant rights and compliance with the applicable rules and regulations. The complainant shall be afforded a fair hearing, provided the basic safeguards of due process, which shall include the opportunity to examine before the hearing all documents used by the housing entity in its original decision, the right to be represented by counsel or another person chosen as their representative, the right to present evidence and arguments in support of his or her complaint, to refute evidence relied on by the housing entity, and to confront and cross-examine all witnesses, and a decision based solely and exclusively upon the facts presented at the hearing. The board may render a decision without proceeding with the grievance hearing if the board determines that the issue has been previously decided in another proceeding, or if the complainant pertains to issues not within the control of the housing entity, whether it be regulations, statutes, etc. You cannot overrule those. If the complainant fails to appear at the grievance hearing, the hearing panel may dismiss the grievance, proceed without the complainant, or they could reschedule the hearing one time if the complainant has proved or provided a valid reason for failing to appear. At the hearing, the complainant must state the complaint, show and make a showing of entitlement to the relief sought. Your housing entity must demonstrate that their action is justified and in accordance with your procedures. And the hearing shall be conducted informally by the chairman of the board, and oral or documentary evidence pertinent to the facts and issues raised by the complainant may be received without regard to the admissibility under the rules of evidence applicable to a judicial proceeding. Your decisions, after consideration of the facts, your board will render a decision within 30 calendar days of the date of the formal hearing. The ED will prepare a letter for the chairman's signature, communicating the decision of the board to the complainant and to your staff. Depending on the nature and extent of the complaint, the written decision may include a statement of findings, conclusions, basis for the decision, and you shall retain a copy of the decision in the tenant's folders along with all of the relevant information. You should have a disclaimer that the grievance policies and procedures and any decisions made by the housing entity and the board shall not constitute a waiver nor affect any manner whatever of any rights of the complainant that they may have to a trial de novo or to a judicial review in any tribal judicial proceedings which may thereafter be brought into the matter. The use of a grievance policy and procedure does not prohibit your housing entity from commencing legal eviction proceedings and or taking action at any time to protect its legal rights and interest. So for those of you that don't know that legal jargon there, in the law, the expression trial de novo means a new trial by a different tribunal. A trial de novo is usually ordered by an appellate court when the original trial failed to make a determination in a manner dictated by law. When there's something I don't understand, I always like to have a little informational tidbit to help. So you should have an applicant-tenant grievance form, statement of grievance, background activity leading to the complaint, including the dates. What kind of remedy do they want? It's the purpose of the grievance procedure to establish a method whereby grievances of tenants and home buyers or applicants even will be resolved fairly and effectively. The filing of a grievance will in no way prejudice the status of the applicant, tenant, home buyer. Please see the grievance policy for a full description of the procedure and make sure that they always sign and date it. So that is a standard form that you should have within your office. Your other federal laws, we got to watch the relocation and acquisition. Must comply with our Uniform Relocation Act at 1014. Maintain records to demonstrate compliance. We have to notify any relocating families, individuals, businesses, and other affected parties. Paying temporary relocation and displacement benefits. The cost of relocation assistance is an eligible project cost, may be paid from tribal, TDHE, and other funding sources. And we have to follow real property. The NAHASDA specific requirements are found at 1014 for relocation and real property acquisition. Applicable relocation and real property acquisition policies applicable to NAHASDA should include and cover under 1014 real property acquisition requirements subject to 49 CFR Part 24 Subpart B. Must be based on an appraisal value. You can accept a donated property or purchase property as long as it's less than the fair market value. Okay, so there's some strict rules when it comes to you procuring property. It requires HUD approval if the purchase price actually exceeds the fair market value. You're to minimize displacement. You have to try to take all reasonable steps to minimize the displacements of persons, households, businesses, nonprofit organizations. Temporary relocation covers tenants and homebuyer relocation cost and adequate advance notice. Okay, this can kick in other cases. You have an apartment building and somebody's using meth, or you have a fire, or you have to relocate people through no fault of their own, okay? Sometimes these relocation things kick in. Be very careful with them. Call your HUD office. That's what they are there for. They will help you. Say, hey, I just had this happen. Do I have to be aware of anything to do with real property, relocation and real property acquisition? Or in the case of you're trying to modernize and rehabilitate fully occupied units and you're requiring them to bounce from one house to the other or something like that, this can also kick in. Call HUD, ask for their advice, they'll help you, okay? Relocation and acquisition. The acquisition is subject to 49 CFR Part 24, Subpart B. You negotiating fair market value when it's a voluntary transaction, following involuntary procedures when required by a URA. Real property NAHASDA specific requirements at 1014, relocation and real property acquisition. Relocation assistance for displaced people. If in case of a permanent relocation, they have to comply with the URA and the Real Property Acquisition Act of 1970 as amended, and implementing regulations found at 49 CFR Part 24. As I said at the beginning yesterday, we have more policies and procedures than almost any other program, and they go into things like this. They go into tribal preference. They go into environmental reviews. There are a lot of areas, especially you that are on the tribal council, where your legal staff, your environmental staff can be of a big asset to your tribal housing entity. We can't be experts in everything, but we can try. So appeals to the recipient allows a written appeal by persons to the recipient. Responsibility of you as the recipient has to certify you're going to comply with the Uniform Relocation Act and those regulations at 49 CFR Part 24, provisions of the regs at 1014. The cost of the required relocation assistance is an eligible NAHASDA cost. Such assistance can be paid with funds available to the recipient from other funding sources, and the recipient shall maintain records in sufficient detail to demonstrate compliance with 1014. I'm almost done, guys. Affordable, and I apologize. Housing developed, acquired, or assisted under the IHBG program is subject to limitations on cost and design standards, okay? Those are found at 1,156 and 158. You have to build of moderate design defined as housing with such a size and amenities consistent with unassisted housing offered for sale within your tribe's general geographic area to buyers who are at or below the area median income. Applies to all housing assistance such as development activities, acquisition, new construction, moderate or substantial rehab, affordable housing, or homebuyer assistance and model activities. So we have to follow non-dwelling cost and design standards. We have specific requirements. Standards must be able to support the reasonableness and necessity for factors used in the activity. You have to document the need or problem to be solved, how it supports an affordable housing activity as required at 1062B-2. 1158, per the ways in which a recipient can demonstrate meeting that moderate design requirement described in 1156, you must use either the TDC limits published by HUD, PIHA 21919, and I need to fix that because there's a brand new one hot off the press a month ago, okay? There's new TDC limits. Look them up. Adopt a written standard for affordable housing programs that reflect the requirements specified in 1156, must be of moderate design, must describe the type of housing, explain the basis of the standards, the use of the similar housing in the tribe's general geographic area, must be available for review by the public, and upon request by HUD, must complete a comparison of the cost using its housing standard and the TDC for the area, and does not require HUD approval if the cost does not exceed 10% of the TDC maximum cost for that project. Non-dwelling structures must support an affordable housing activity and design. Size and features, amenities have to be reasonable. You can find and read about that at 1060. If funds from two different sources are used to develop, the standards of the funding source with the more restrictive rules actually apply. So the recipient can adopt written standards for non-dwelling structures, describe criteria to be used for the cost, the size, and the design. Your labor standards, you have to have that policy about your Davis-Bacon Act and monitoring. Your areas that fall under your Davis-Bacon are areas affected, your construction and your development. The scope is the procedure that identifies the steps required to monitor Davis-Bacon Act requirements by your housing entity. You should have procedural steps put in place. When required by federal regulations, all laborers, mechanics employed by the contractors or subcontractors to work on construction projects of your housing entity financed by federal assistance have to be paid wages not less than those established for the locality of the project by the Secretary of Labor. That means the minute that you want to spend more than $2,000, you have to look up what the Davis-Bacon is and request those wages. So you're following them. They can't be paid less. If applicable, the following procedures shall be followed to effectively monitor this federal requirement. The development coordinator or whoever you have in place, your assigned staff, will prepare and submit a request for a wage determination form for all federally funded construction and or reconstruction activity. Include a provision in all federally funded construction contracts in the specifications requiring the payment of Davis-Bacon, your prevailing wage rates. All contractors performing work requiring compliance with Davis-Bacon Act will submit payroll reports using a HUD form WH-348 or its equivalent, which should contain the following. And it needs to go to your labor compliance officer or who's doing your construction, whoever's your point person. The name of the employee, what the rate of pay they're receiving, their job classification, the time period that that employee worked on the federal program. They should actually keep notebooks, is what I always advised them. When you step forward on the reservation land, I want to know what you did, how long you were there, and when you left. Your labor compliance officer will periodically perform job site interviews. That's somebody on your staff is supposed to be doing this, out in the field, talking to these guys. So when you have your pre-construction meetings, you make sure that they tell them. In my case, they used to say the girl with this long brown hair is going to be out here. She's going to ask what you're doing and how much you're getting paid, and you need to tell her. And I would be out there at least once every 2 weeks. And you need to log that you were doing that. Periodically perform those job site interviews to determine the actual rate of pay that employee is being paid. You refer to the record of the employee interview form, HUD 11. Compare the rate of pay from the job site interview to your wage determination as appropriate for that job classification. That's why you need to know what they're doing. A drywaller is going to get paid different rate than a laborer or a painter. If there's any discrepancies between the interview and the submitted documents of the contractor, appropriate action will be taken to bring the contractor into compliance with this requirement. The result of these interviews and follow-up investigations will be maintained in your contract files. So What does your tribe use for a prevailing wage rate? We're almost done, guys. I'm so sorry. 10 minutes late. Do you use Davis-Bacon? Do you utilize a tribally adopted wage rate? You're supposed to use one or the other, or you don't know. I'm trying to read the questions real quick, too. Okay. I know. Northern Circle in the house. Hi. Philip Brown left. Okay. And Kayla's leaving for lunch. Okay. Wow, we got quite a few of you that utilize tribally adopted wage rates. That's awesome. Make sure when you're doing your APR, it's going to ask you which one you're using and if you're using both, and in which case, why. Okay. We've got some I don't knows. Hey, it's pretty even split though. You can close that up in the interest of time. Thank you guys for answering. And useful life. Almost done, guys. Useful life is the period of time during which a low-income rental housing or your home buyer housing has to remain affordable as required under Section 205, A2, and 209 of NAHASDA. The useful life requirement requires that housing units have to remain affordable for either the remaining useful life of the property, which is determined by your secretary by the approval of your Indian housing plan, or such other period that the secretary determines as the longest feasible amount of time. Okay? This is because the money we receive is appropriated by Congress for low-income Native Americans. If you give somebody down payment assistance and their useful life is 10 years and they sell it at 2 years and some rich non-Native ends up in that house, the benefit of that money did not go to a low-income Native American. Trying to ensure that it does, okay? Requires a useful life description in your Indian housing plan, so you're going to spell it out there. Applies to new and rehab. Basically applies to any use of your NAHASDA funds for building, fixing, rehabbing, Does not apply to a mutual help unit. Going to give you a caveat. I hit on this yesterday. A mutual help does not apply to a mutual help unit built with 1937 Housing Act funds, okay? If you got NAHASDA and decided to duplicate the 1937 Act mutual help activity that we all put forth, it's truly not a mutual help unit. It's something that's structured like that, and you need to change the name, okay? Because it can get you into trouble. Your affordability period. When your Indian Housing Block Grant funds and or Title VI funds are spent on a property as an investment to be made on the behalf of a low-income Native family. The return on that investment is the period of continued use during which that property will be available for use by low-income Native families. Your program guidance, 2020-02, clarifies what could be considered satisfactory to the secretary, what constitutes an acceptable binding commitment. There was also in those guidance appendixes 2014-09, which provides samples to document useful life with housing units assisted with those funds. Your affordability period is the future use. The future use is the affordability period or useful life for that property. A useful life or an affordability period must be established for housing units that are constructed, acquired, rehabilitated using IHBG or Title VI funds to ensure that that property is available only to low-income families for the specified useful life of the property. And this is what the guidance from 2020-02 looks like. This is a fairly widely used throughout Indian country and accepted example. Under 5,000, your affordability period could be 6 months. 5,000 to 15,000, 5 years. 15 to 40, 10 years. Over 40, 15 years. New construction or acquisition of a newly constructed housing, 20 years of affordability. Minor investments, the affordability period can be nominal, but they do require, NAHASDA requires that some period be designated and then it be secured with a binding commitment. If the period is less than a year, it is not necessary to record that written use restriction for purposes of complying with NAHASDA. But it's a good business practice to record the use restriction for purposes of giving notice to your subsequent purchasers. A binding agreement is satisfactory, that is found satisfactory to HUD, is a written use restriction agreement developed by you as the recipient, placed on an assisted property for the period of its useful life. Program Guidance 2014-09 provides some sample binding agreements. You can use a single recovery amount or a prorated recovery amount. So that is the decision that you have to have made within your agency and your leadership. Fee land with a single recovery amount requires that the full amount of your assistance be refunded or returned to, your housing department should that property be sold or transferred prior to the end of the useful life. So if it was a 20-year period and they made it 18 years through, if you had a single recovery amount, they'd have to pay you back all of it. Fee land, a prorated recovery amount. The amount of funds invested in the property can be prorated over the life of the restriction. In the event of a default, only the current prorated amount must be refunded. And you have to spell out the payment method, how much it's going to go down per year, and have that all spelled out within your policy. That's the method that we used. Recommended tracking methods: maintain a spreadsheet, property address, owner's name, how much money was spent, the affordability period assigned, the date that you assisted it, and what kind of binding commitment do you have in place. So when we were talking about self-monitoring, this is one of the examples that HUD uses. This is one of the things they catch. So if you did that yourself as part of your self-monitoring and put this in each one of your files, you would keep yourself out of trouble. Your unit information, the number of the property, your address, the location, the land status, what type of unit it is, who the current owner is, when did you give them assistance, the type of assistance, thank you so much, the amount of the assistance, the funding sources required in the restriction, the use restriction document, the length of the restriction, and the start and the ending date. My throat's saying, "You're done, woman, shut up." Enforceable agreements. Participant agreements, liens on the property, recorded through the right agency, and forgivable loan agreements or conditional grants. You have to decide which. Your lien requirement. The housing department of the tribe retains the right to place a lien on any property assisted with NAHASDA funding, subject to its useful life requirements to secure the housing department or tribe's interest in that conditional grant. The participant shall execute any documents which are necessary to perfect such lien and shall ensure that all other persons who possess an interest in the subject property timely execute any documents which are necessary to perfect such lien. The housing department and tribe shall provide the participant with notice of any such lien in accordance with applicable law. If the property assisted with the funding under a program is trust land, the lien shall be recorded at the Bureau of Indian Affairs, Land Titles and Records Office, with jurisdiction over the tribe. If such property is fee land, the lien shall be recorded with the appropriate county register of deeds. The tribe, in its discretion, also may record a lien involving trust land with the appropriate county register of deeds. The lien shall remain on the property until the conditional grant is satisfied in full by either forgiveness or repayment. Upon satisfaction of a conditional grant, the housing department shall release the lien. Upon death of the participant, the descendant's estate shall not be required to repay the conditional grant, and the lien shall be released provided the descendant was compliant with the terms of the applicable housing program at the time of death. Make sure you have clear title on anything that you deal with your NAHASDA funds. Housing funds shall not be spent on the acquisition, construction, or rehab of any parcel of land that does not have clear title. Prior to such expenditure, a title search shall be conducted to confirm title is clear in regard to the land being assisted with your housing funds. Language appears somewhere. Tax compliance. Housing funds shall neither be spent on the acquisition, construction, or rehab of any parcel of land that is delinquent or facing delinquency in tax payments, nor be used to pay the taxes. It's illegal to pay taxes with NAHASDA funds, by the way. Nor be used to pay the taxes of any participant in any situation whatsoever. This requirement shall commence at the time housing funds are first spent and shall continue the entire time in which the housing department has a financial interest in a home or parcel of land as applicable. Insurance. Housing funds shall not be spent on the acquisition, construction, rehab of any home or parcel of land that is not insured against casualty, fire, flood if necessary. Any home in a floodplain as designated by the tribe's environmental resource staff shall be adequately covered for flood damage or destruction of the home. The foregoing requirements shall commence at the time housing funds are first spent and shall continue the entire time in which housing department has a financial interest in a home or parcel of land as applicable. Participants in the rental assistance program, student temporary housing assistance program, and emergency assistance program who have not exercised the option to purchase under the lease to purchase shall not be required to insure the housing unit, home or rental unit. Nevertheless, the housing department shall encourage any participant who rents to procure renter's insurance. The housing department shall be named as the loss payee under all required insurance policies for the period of the conditional grant of a program, or until the conditional grant obligation is satisfied. The participant shall provide the housing department or tribe with certificates of insurance evidencing required insurance. So when you put NAHASDA funds out there, you need to make sure that that investment is protected. So we're supposed to have flood insurance. If you're in a FEMA identified special flood hazard area, it requires participation in the National Flood Insurance Program or private flood insurance. Many of our reservations have not been mapped by FEMA. We have to make sure that in all situations, we're observing the lead-based paint. The lead regulations are at 24 part 35. It took effect in 9/15 of 2000. There's more information through this link. Include on a standardized tenant homeowner checklist. You could say all of our units were built after 1978, so therefore none of our rental units contain lead-based paint. And if you put that statement on there, then hopefully you won't get the finding about passing out the lead-based paint required materials. But you still have to pay attention, because if you're giving down payment assistance, if you're doing rehab, energy assistance, you have to make sure that there's no lead-based paint present in the homes in which you're using your NAHASDA funds. Okay. Questions, guys? And I apologize for being so late. And I will see you tomorrow at 2 o'clock. And she's got a survey for you. And there's my info.
Thank you so much, Cheryl. While I close out this webinar, please feel free to go ahead and write questions that you have. I'm going to go ahead and launch today's survey. If you could please just let us know what we could work on. For those of you, just a reminder, who chose time as an issue, please let us know what exactly more you would like. Please specify what you mean by time, so that way we can try to fix it to our best ability.
I think what she means is, would you like this course to be a day-long course? Would you like it to be 3 hours at a crack? Or what areas do you want expanded? But I don't know, because I don't know what you said.
And for those of you who felt like you couldn't write everything quite down, I do have the PDF version in file, so you can always have the presentation downloaded. That way you can refer back to it. I also provided the link for the day 1 recording, so that way you guys have that to jump back to. Our next webinar is going to be day 3, which is tomorrow, September 1st, NAHASDA Required Policies and Procedures 3. It will be at 2 p.m. Eastern, 1 p.m. Central, 12 p.m. Mountain, and 11 a.m. Pacific. Registration is free as always, so please go ahead and register at the link. I just went ahead and put the registration link in the chat box, but the PDF file is located on number 1 under files, and if you just click that little downwards arrow, you'll be able to download it. Feel free to access this and any other recorded webinars on our website, www.nativelearningcenter.com. We have a Catheta webinars tab and a recorded webinar section. You can click on any one of the webinars that we have done for the past 18 months. Please feel free to view them and share them with your friends and colleagues. Please check out our upcoming events as well on our social media sites, such as Facebook, Instagram, Twitter, LinkedIn, and Snapchat. We even have a podcast. You can find that on Simplecast, Google Podcast, Spotify, and Apple Podcast. Once again, I want to thank you all for joining us today and participating. Have a wonderful day, and hopefully we'll see you again for tomorrow.
Everybody stay safe.
Yes, Dorothy, you do have to register for tomorrow because tomorrow is a whole separate webinar, so you do have to register for it. I did put the link in the chat, so if you just want to go ahead and click that, it'll take you right to where you need to register.